Hello and welcome to this video for charities on preparing for the end of the Brexit transition period from a data protection perspective. So this is the first of 3 shortish videos designed to help charities understand what you need to be doing to prepare and to make sure that you are comfortable that you will continue to be complying with data protection laws after the end of the transition period, i.e. from the 1st of January 2021. This is a kind of relatively short, as short as it can be, overview introduction, and this video is one of 3 in a little mini-series. So I recommend that you watch this one first in full before moving on to either of the other 2, if indeed those other 2 are relevant to your charity. So this video is for charities, not-for-profits, other kinds of social businesses. That's the focus anyway of my talk, although most of what I'm saying will apply in the same way to other individuals or organisations that process personal data. By process, we mean do anything effectively, so from collecting it to storing it to sharing it to deleting it. So basically this is for anyone whom the GDPR currently applies, and we'll soon hopefully get used to calling the GDPR the EU GDPR, and we will have separately the UK GDPR. So taking a little step back first, what happens to the GDPR, i.e. European law, after 31st of December this year, i.e. when the end of the transition period comes? Well, the UK officially left the EU, obviously on the 31st of January this year, but during this transition period, UK has effectively kept European law, and European laws have continued to apply in exactly the same way. But from January, after the transition ends, that won't be automatically the case. The GDPR as a regulation won't automatically apply in the UK anymore. Instead, we'll keep the GDPR effectively by transposing pretty much the whole thing into UK law. There'll be a few technical changes so that it makes sense, the drafting makes sense now that we'll be outside of the EU institutions and frameworks such as the European Commission, but it will basically be a wholesale transposition of the GDPR we're used to. That will become known as the UK GDPR, and it will sit alongside the rest of the existing UK data protection legislation. So mainly we're talking about the Data Protection Act 2018 and the Privacy and Electronic Communications Regulations, or PECA. The Data Protection Act is also going to be amended slightly so that it kind of dovetails into this new UK GDPR. But for the initial period at least, the EU GDPR and the UK GDPR will effectively be identical for all intents and purposes. What is the case, though, is that the UK will be able to change our UK GDPR after that date, if it so wishes, and it will be free to decide not to adopt any changes that the EU makes in the future to its data protection laws. So we might find that over time, the 2 GDPRs, or the 2 data protection law regimes, diverge slightly. So coming back to this UK GDPR, who's that going to apply to? Well, it will apply to controllers and to processors of personal data. So basically anyone who is using personal data who is based in the UK. So I think that will be most people watching this today. Controllers and processors based outside the UK might also be caught by the UK GDPR if they're offering goods and services to people in the UK, or if they're monitoring the behaviour of people in the UK. So they might have to comply with both the UK and the EU GDPR if they operate in both of those areas. So what about UK controllers and processors, i.e. you, charities based in the UK, who also want to continue to operate in the EU after the end of the transition period? Well, the flip side of what I've just discussed in relation to the UK GDPR is that organisations like yours in the UK, including charities and not-for-profits, will still have to comply with the EU GDPR as well as the UK GDPR if you have an establishment in the EEA, or the European Economic Area, if you provide services to people in that area, or if you monitor people. So these are quite sort of technical definitions. They have a special meaning. So having an establishment in the EU isn't just as simple as having a branch or an office, though that would probably qualify. It can also be something more like a website targeting people in that particular country that perhaps is in the language of that country, has a mailbox in that country, if you have representatives working in that country. In the language of the case law on this, you're carrying out a real and effective activity through stable arrangements. So as I say, it's not necessarily as simple as just saying, well, we don't have any offices in the EU, so we don't have an establishment. If you're doing something quite stable, then perhaps you may have an establishment. Even if you don't have an establishment, as I said, you might be providing services, or probably less commonly in our charity sector, you might be providing goods targeted at people who are in the EU. So again, it's not necessarily a completely straightforward test, but you will need to be clear about whether you are providing those services, i.e. targeting people in that area, because that will mean that as well as being bound by the UK GDPR in this country, you'll also continue to be bound by the EU GDPR. And as I say, it could be that those two regimes diverge over time. The monitoring of individuals, I'm not going to go into that particularly now because I don't think it's something that most charities do, but it would involve monitoring, for example, people's personal preferences, their interests, their location or movements, or perhaps even their health. So what does this mean in practice? Well, for the time being, there's unlikely to be any significant departure from the two legal frameworks. So I think in the short term, the implications will mainly be felt in circumstances where you are transferring personal data between the EU and the UK, and or where you're doing work in the EU and you're going to need to appoint an EU representative. Now, each of those topics is covered in more detail in the second and third videos in this series, so please do have a look at those. The only last thing that I wanted to mention in this video is the implication of this departure on the role of the Information Commissioner in the UK. So that's the ICO, the Information Commissioner's Office, as the supervisory authority for data protection in the UK. Some of the detail here is pretty technical. It relates to the ICO's role in making adequacy decisions for the EU, approving standard contractual clauses for the UK. Oh, sorry, I should have said adequacy decisions for the UK, approving our own standard contractual clauses, or in relation to binding corporate rules. We'll touch on some of those things in the second video on transferring data. But as I say, relatively technical points. The key change, though, that I do think charities should be aware of is that the ICO will no longer be part of the EU regulatory regime after 1st of January 2021. And that means it can't any longer be a lead authority for cross-border processing. So if you know that your charity has designated the ICO as your EU lead, or you know that a group company or organisation or group charity has done that, they'll need to think about designating a different EU supervisory authority as their lead. Similar to that, what's called the one-stop shop, the idea that the GDPR introduced, that regulatory action should only be taken by one lead supervisory authority in one member state, won't apply anymore. And that means that you might have to deal with the ICO and another relevant lead authority in the relevant EEA country where the processing is taking place. Now, technically, that could mean that organisations who are processing data in the UK and the EU could face enforcement action, penalties, fines even, in both the EU and the UK for exactly the same breach. One fine under the EU GDPR and one under the UK GDPR. Now, this isn't something that the UK government wants, and probably isn't something that the EU will particularly want either. So I think we will see some form of continued cooperation on enforcement. And there is a kind of mechanism for that potentially in the GDPR, although it's a little bit untested at the moment. So I'm going to end this video there. As I say, it is intended to be quite a high-level introduction to make you aware of the things that should be on your radar, that you should be thinking about over the next few weeks before we reach the end of 2020. There might well be concepts that I've referred to in this video that aren't familiar to you. And the ICO's website is as good a place as anywhere to start for further information. But it really is something that I think charities need to make sure that they have thought about quite carefully and that they have tried to get to grips with in the next couple of months, even if just to satisfy yourself that the EU GDPR won't apply to you after the 31st of December.